Hi, I'm Debbie Moraes. This is Legal Matters, the program that's been designed to address current, critical, sometimes contentious issues that are facing consumers and businesses today. It's legal information, practical solutions, and straight talk about a wide variety of topics that will affect your home and work life. Let's begin by welcoming our program sponsors, Bazar Grasso law firm in East Providence, Jackie Grasso, and to our left, David Bazar. So today, a topic we haven't really tackled much, the idea of prosecutorial misconduct. Prosecutors within our justice system, they certainly wield an awful lot of power. If you happen to be accused of a crime, you really do care about how they have to prepare and present a case. They're obliged to play fair, but wouldn't you be surprised to find out that they don't always do it? Of course you want to win, but you've got to play fair. There have been many headlines that point to the fact that there are rampant cases of prosecutorial misconduct. It happens nationally, it happens locally. So let's go through what you should know and how you can help your attorneys perhaps prepare better, what your attorneys are doing to make sure that this doesn't happen to you. So let's go over, there are many sins about prosecutorial misconduct. Most recently in the news was a story about, from the New York Times, about how a particular judge decided to take issue with it. What are some of the prosecutorial issues of misconduct, like withholding information, for example, that you know of?
That seems to be the most common that people identify with. It's withholding information that could be beneficial to the defense. So we call it withholding exculpatory evidence. And for instance, if the prosecutor had something that would benefit the defendant in helping the defendant maintain his or her innocence, and they're withholding that just solely for the purpose of getting a conviction, that's misconduct and sanctionable and subject to disbarment as well.
So I would say that it's not really as widespread as it seems.
Yeah.
When it happens, it's reported and it's wrong. Most prosecutors and most defense attorneys know that the judicial system and the integrity of the system is the most important thing that they're doing, not to win or lose at all costs. That's not the issue. It's to seek justice and do justice. But Jackie's 100% right. There's an obligation under the law and the rules that if you have information as the prosecutor that is exculpatory or helpful to the defense, you have to turn it over. You can't hide evidence. You're not supposed to bury it in a mound of other evidence that's irrelevant. You're supposed to uphold the integrity of the system,
and of
both
course,
sides.
And of course, if you happen to be the indicted or the person who's accused of a crime, if it affects you, it really affects you personally. You're pointing out that even if it didn't affect you personally, it's certainly saying that the system's broken if this happens. How about on your side of the fence, if you're the defense attorneys, if you find out something, are you obliged to turn that over to the prosecutors if it, say, would help his case? Because all you're there to do really is to help do you have the same kind of rules to play fair? Do you have to show him his as much as he has to show you what he has? Is it inculpatory?
Inculpatory evidence, if you will. The rule is that you have a defendant who's presumed to be innocent and does not bear any burden of proof and does not have to do the prosecutor's job or help the prosecutor with his case. So unless you're going to use evidence for your defense, such as if you know some alibi witnesses are going to testify or you have an alibi defense, you're supposed to present your alibi witnesses in defense to the prosecutor so they can investigate it and have like I said, integrity of the judicial system. But if you have something that is not going to help you, there's no requirement on the defense side to help the prosecutor make his or her case.
Good to know. So knowing that the prosecutors are appointed by an elected official, hate to say it, but elected officials, they want to win. Prosecutors want to win, you want to win. But doesn't it make sense that one of the reasons we've been hearing so much about it is those prosecutors may want to win, but often will hope that you didn't find out that they had ended up with a piece of police report, short of DNA material. How do you end up working with your clients as a defense attorney to make sure that you have everything that they possibly ever fell over or discovered or filed away?
Well, that's how you build your case. You need to get every bit of information that your client is going to disclose to you. So if there's a police report, you have to get the police report. If there was an alibi witness or another witness that they're aware of, then they need to disclose those. You need to, as an attorney, make sure you interview all your witnesses. Any physical evidence, you need to be able to have access to that as well. I mean, your case is only going to be as good as you're going to prepare for it, and it's up to you as the attorney to get this information from your client.
Yeah, the client usually will know as much about the prosecutor's case as the prosecutor.
Yeah.
So in a very careful manner, because you have a duty to the judicial bench as well, not to present evidence that you know isn't correct. So you can't have your client tell you, even with attorney-client privilege, oh yeah, I did this, this, and this, but I'm going to get up on the stand and I won't say that, or I'll lie about it. They can't lie. And you can't bring perjured evidence that you know about to a trial and put it in front of a fact finder or a judge. So in a careful way, you build your case with your client. You find out everything that's relevant and that can be helpful to your case. And you also want to know everything that's not helpful to your case, because you've got to assume at some point in time the prosecutor is going to learn that information too. So you need to know how to deal with it. So it's through your client and then through investigation or whatever else you have to do that you can build a case.
Because there have been incidences, whether they were intentional or unintentional, obviously prosecutors aren't infallible. I'm sure they make honest mistakes, and of course that's another issue for us to talk about later. But there have been these kinds of misconduct issues. The Brady issue that they talk about, the Brady disclosure, that happened, was it 1963? So that's quite some time ago. Yet the cases that we've been able to read about in preparing for this indicate that an awful lot of people are still getting away, a lot of prosecutors are getting away with not disclosing everything, even if it happened to be that a little boy happened to say, that man who killed Mommy had a mustache, and oh, by the way, that never comes out because it got buried somewhere in a police report, or hearsay when a police officer talked to a little boy. How can this continue to happen if there is such a law or a disclosure in place, this Brady issue that's supposed to clarify this?
I don't have any explanation for that, except that apparently it slipped through the cracks and nobody realized it. There's a prosecutor who actually was in prison for 10 days in Texas, I think it was,
yes,
just this past year, several months ago, and I believe he is serving or was serving as a public official at the time, if I recall. But what happened in that case is that particular prosecutor had withheld exculpatory evidence, and later on it was the defendant that found out about it. I think it was DNA evidence. I'm not sure of all the facts. But later on, over the years, having someone investigate, probably hired a new lawyer, they found out that this happened. And finally, for one of the fewest times that you hear about it, the prosecutor was sanctioned and was penalized and had to serve 10 days in jail.
If a prosecutor intentionally withholds information, it's a violation of their ethical rules. It's a violation of the rules of criminal procedure. The court can have a hearing and hold that prosecutor in contempt. Just like if a defense attorney doesn't follow the rules, they're subject to the same rules of ethics and the criminal rules of procedure, and a judge can hold that person in contempt, or there could be criminal cases filed in some instances. So the bottom line is, for both the defense attorney and the prosecutor, you have an obligation to present your case as vigorously as you can. You also have an obligation to the integrity of the judicial system and making sure that you're following all the rules that you're bound by.
So, Jackie and David, recently in the New York Times, when one judge, who was a chief judge of the U.S. Court of Appeals for the Ninth Circuit, he ended up finding that a man named Olson, who was convicted of producing ricin, apparently the prosecutors had a witness, but the witness had been a little bit sloppy. And the long and short of it was that they figured that there was such overwhelming evidence that it really didn't matter that the guy was sloppy. Well, based on that, the long story short is that the judge said this wasn't right, this wasn't fair, and so now you have an issue of prosecutorial misconduct, whether the prosecutor did it intentionally or not. Still, it was in the judge's court, literally, to call someone. Are you always at the mercy or at the hopeful end of the stick when the judge makes this decision that there's been some prosecutorial misconduct, or do you guys get to say something's not fair here?
Oh, I think if we as lawyers have any inkling that that's happening, we have an obligation to disclose it to the court.
And on your client's
and
behalf.
And to your client, you have an obligation.
If you know that they've done something wrong, or you suspect it, and you raise it with the judge, there's some discretion based on what has happened that the judge can, bring to bear. The judge could throw a case out based on it. If it's such an egregious thing that your right to due process has been violated and double jeopardy has attached, you might not even have to be subjected to a second trial. It may be something minor and not so egregious, and maybe something where the judge says you're entitled to a new trial, or there was, as you said, maybe in a case there's such other overwhelming evidence and this was a minor thing that I'm going to sanction the prosecutor, but I'm not going to disturb the jury's verdict if there was a jury verdict.
That reminds me of the Plunderdome trial when there was a gag order.
Right.
And there was information that was let out by a prosecutor.
Right. And the judge let the case go
Correct.
forward,
Correct.
but did sanction the prosecutor.
Correct. Okay.
I understand that there are things that can happen that are just human error. Maybe they call them harmless errors. There's also an issue about prejudice. I don't know if that's harmless. It certainly doesn't sound harmless. Or malicious. What are some of the other ways that I understand profiling certainly isn't good, sexual abuse and those kinds of things, false arrests, they list false confessions. What are these things, which of these is considered to be harmless and which one's considered to be worthy of the prosecutor being sanctioned, fined, or disbarred, or whatever?
Well, I think they're far and few between. I would think if you're in the middle of your case and you find any of this, it's harmful, not harmless. It depends on what the case is. It depends at the stage in which if they haven't started trying the case yet, have they impaneled a jury. Any of this, if it's intentional, it's all harmful, not harmless.
So something prejudices your case if it's so egregious and so important to your case that it's not given to you. Harmless error, or less harmful error, as Jackie is saying, might be an example of where the prosecutor, in violation of the gag order in that Plunderdome case, gave out a videotape. The theory is it could have polluted the potential jury pool in some way, but on the other hand, the likelihood of that having happened to the extent that it affected the defendant's rights in that case is very slim. So the judge ruled that there was a violation, there's going to be a sanction for that violation, but it's not such a prejudicial event that I have to throw the trial out or move it or do something like that.
When there seems to be an infraction, a minor sin, a major sin, who gets to determine? Do you get to weigh in on whether or not there's an actual retrial?
It's the judge. Well, we have to ask for a mistrial, and then it's within the judge's discretion to make that ruling.
And both the defense attorney and the prosecutor get to argue to the judge where the thing should fall, the misstep on the scale of harmless error to major prejudicial error, infringing on somebody's rights, and then the judge will determine. And as you've cited some cases, those decisions can be appealed, and a court of appeal or the Supreme Court could make a determination as to whether the judge was correct in the first instance in his or her ruling.
I know in past segments we've talked about your ethics and what you do if someone has done something that's unethical or just misbehaved in any way, that you have certain steps that you take to make sure that he or she makes good, makes right, or is disbarred, or something in between, depending. To hear that because there have been, and the word was rampant according to the New York Times, accounts of this, it's hard to imagine, as I've read here, prosecutors are protected from civil liability even when they knowingly and maliciously break the law in order to secure convictions. And the doctrine of harmless error is used by appellate courts to uphold convictions despite such illegal tactics, thus giving prosecutors few incentives to comply with the law. That certainly sounds like a broken system in and of itself. What happens with that? They're talking about civil liability as opposed to some others. Care to comment on that? Personal liability?
Yeah, personal civil liability.
Yeah,
and the point is this: judges have judicial immunity, other state employees have certain limited immunity, and in that particular case, what they're saying is that if the prosecutor violates your civil rights, there may be an immunity that protects them from civil liability, but it doesn't protect them from sanctions for ethical violations, from being disbarred if it goes to that level, from being held in contempt and sent to jail for 10 days, as you cited for somebody else. So there's plenty of incentive in the law to make sure that the prosecutors follow the rules, the defense attorneys follow the rules, and that the integrity, as we've been saying, of the court system is upheld, because that's the most important end result of any case. You don't want to send someone who's innocent to jail. That's why our system is designed the way it's designed. People's constitutional rights are the highest priority. So even if the court and the judge and the prosecutor think that there's enough evidence to find somebody guilty of a crime and send them to jail, if their constitutional rights have been violated to the extent that it's prejudicial and it's wrong, they'll get off, and they should get off. And that's more important because of the system being, the integrity of the system being upheld than each individual prosecution. And you said earlier that the Attorney General is elected, the district attorneys appointed, and these different types of things, and they want to keep their jobs or be re-elected or whatever. I would think most people who are elected to office in that position would be more concerned that their employees and their prosecutors are following the rules of ethics and the law than getting every conviction that they're supposed to get.
Oh, that's absolutely the way it should be. Of course, I think it was in the case that you were starting to refer to somewhere in Texas that by the time someone who had been convicted wrongfully served time, that person who was the prosecutor had somehow graduated and been promoted to a judge, by the time they find out that there was some wrongdoing there.
He was an elected judge.
Elected.
Yes.
But still, he moved through the ranks and some good period of time had passed. So when such is found out, DNA, the Innocence Project, if you want to comment on that, please do, but things like that can show that someone is innocent even after someone's been serving 10, 15 years. Is there any statute of limitations that protects the lawyer from protects the prosecutor? I mean, obviously this guy, we've got to reach back several years. He became a judge and all. Is there anything that the number of years that protects the lawyer who prosecuted from ever being penalized? It can go back as far as they need to?
Well, I would think that the statute would start tolling until they discover the actual offense.
Yeah, and more importantly, the real issue is what you're raising with DNA and the Innocence Project, is someone could be convicted of a crime without any prosecutorial misconduct. You know, there is things that can happen. A lot of times you'll see people raise ineffective counsel as a reason to overturn that the defense lawyer didn't do a good job. There's a lot of things that can go into a conviction. The importance of the Innocence Project, the DNA samples that have been saved and used to find that people have been wrongfully convicted, is that those, for the most part, those opportunities to test DNA didn't exist when these people were convicted. And now you can go back, and I think there was a woman in Bristol or Warren who actually went through this for her brother and was able to prove that he was not guilty of the crime that he had been convicted of. It's a really wonderful project and a really good way of helping people who shouldn't be in jail. But it doesn't necessarily mean that there's been prosecutorial misconduct involved in their initial trial.
Not necessarily, of course.
What you hear, though, with the gentleman that was wrongfully incarcerated or convicted in Texas, his civil rights were damaged, and there was prosecutorial misconduct, and often people say, well, what's going to happen to the person who was wrongfully incarcerated? Oftentimes you see that there are civil lawsuits against the state for that very thing.
Mr. Morton, I believe. Meanwhile, I'm not sure what a civil, well, what does he get? He gets money out of a civil lawsuit. Nothing recoups those 25, 29 years spent in the penitentiary.
I actually recall a case in Warwick where a police officer, he had been the defense attorney, and it turned out that his client was wrongfully convicted, and I think he received a civil settlement from the state as a result of that.
The interesting thing about that case is there was a witness who later disclosed, not a witness, somebody who was already incarcerated, who later disclosed that he was the person who committed that crime.
That's
and I think he was on his deathbed.
Yeah, I think there might have been a jailhouse deathbed.
I think that's what it was. And the person that was wrongfully convicted was a former police officer.
Right. Yeah, and there were some other aspects to the case that made it a little messy, but the bottom line is he did eventually get released, and he did have a civil recovery.
When people talk about things that may color someone's judgment, like the discrimination...
Can I go back for one second?
Go right ahead.
The civil recovery may have been more in line with his police officer position.
I think it was.
And money that might have been due to him and so forth. Go ahead, back to you.
Good point of clarification. So when people talk about what other kinds of sins that these prosecutors could possibly commit, often you hear about them indicting a ham sandwich and sometimes indicting 16 people hoping to get one or the other. Explain a little bit about how that system works so that it would possibly help the prosecution to try to blanketly send out these indictments, which is easy to get, consequently the expression indict a ham sandwich. How does that hurt your client when they want to go after many and just see if they can sniff around? Is that that's not the technical term?
Well, fishing expedition might be the technical term. The grand jury is a process that's supposed to be secretive. Only the Attorney General as a lawyer can go in front of the grand jury, and therefore they control a lot of the process as to how that works. You're a potential target or a witness for the grand jury. You can have a lawyer outside of the grand jury room, but the lawyer can't go in with you. And the grand jury often relies on the Attorney General who's presenting evidence to get their direction from that person. So that's why they say you can indict a ham sandwich, because they do control so much of the process. Theoretically, the grand jury is an independent body that's supposed to come to its own conclusion and determine who is or who is not going to get indicted. So that raises a whole other issue. When you start bringing evidence against a whole bunch of people and you know that there's really nothing there but you still do it, does that rise to the level of prosecutorial misconduct? When you send someone, when you try to present evidence against someone through what's called an information, because you can have two tracks to bring a criminal case, an indictment through the grand jury, or the Attorney General can send an information to the court saying this person is guilty of a crime, and the person can go through the court system through the information. The issue then becomes, and sometimes people raise this, is, well, let's say there was 8 or 9 of us involved in something, and they're only going after me. Is that prosecutorial misconduct? Or maybe they're going after you first because they think they can break you to bring more evidence. Well, the prosecutor also gets discretion. So prosecutorial discretion is not the same as prosecutorial misconduct, unless the prosecutor is bringing a case that they know has no merit. That would be an abuse of their discretion.
But if they might have found that this person that they're really going after might not have been guilty of this crime, but we know we've got him close to dead to rights on other things, we just want him. Does that then become misconduct? They're getting him, which is what they wanted to do, and probably he's done other things, but not necessarily that crime. Is that misconduct?
That would be misconduct, because when you bring a case against somebody, you bring it based on a certain set of facts, and if those set of facts you know either aren't true or they don't amount to a criminal case, and you know it when you bring it, you've stepped over the line.
And what about what happens when even the Law and Order, those people...
I was just going to say that too many... it sounds like a Law and Order television
It
show.
happens, but you will also read and hear about stories where the prosecutor might say that I really want to make a deal with someone. Horse trading even with the defense attorneys. How does that happen, and what do you end up doing to make sure that it doesn't? Horse trading in that you're a defense lawyer, I think I want this guy that you have, not that guy. I'll help you with yours, you help me with mine. How does that work?
To me, that's prosecutorial discretion.
Yeah. That's discretion.
That's discretion, and I think it's rightfully placed that the prosecutors, the police officers, the people involved in, as you say, in law and order, there's the prosecutors and the investigators. The people involved in that aspect of criminal cases are entitled to make determinations with their discretion as to who is the important person involved in this and who is the one that we really need to make sure we bring to justice. And if we use people going up the ladder to do that and make deals with people to do that, they can do that. Now, of course, when they get to the person they're looking for and they've made deals, and those people are not going to testify against that person, they have to disclose what deals they made.
They disclose it in the court to you in a private session?
It's got to be disclosed in open court.
And how will that affect your clients working with you? David, I don't think that's nice. Jackie, I don't approve. Why should I be held maybe feeling like I'm a victim because of that?
Well, it's part of what goes into the original deal when they make it. You can go from, we'll go for a lighter sentence to, we won't prosecute you at all and we'll put you in the witness protection program. Whatever the deal is, if a deal is made, and you're going to now testify against someone else, the defense attorney for that other person needs to know that so they can cross-examine you to make sure the jury knows where you're coming from and why you may be saying what you're saying. So it's part of the whole integrity of the system thing again.
When it comes to something like DNA, black and white issues, some of those things you can prove. How do you end up defending your client against prosecution who just plainly might be vindictive? How do you deal with that?
Well,
not so black and white.
I would hope, but I don't practice criminal law, so maybe David can answer this. If somebody's being vindictive, I think the handwriting is on the wall and you can see it, and I would hope that the defense attorney would immediately bring that to the attention of the court.
How do you substantiate that? How do you even begin to deal with that?
It's a difficult situation. A lot of times clients will come and say that a certain police department is harassing me. I get pulled over every other week for nothing. I had a tail light out one week. My license plate had salt on it from the road and I got pulled over. So if those things continue to happen and there's no particular reason for them, the first line of defense would be to contact the police department, and they have these investigators inside the police department that will look into things and try to determine whether or not something is happening outside of the bounds of fairness.
And they would disclose that to you as a lawyer?
Well, as a lawyer, you could walk your client through the process and be part of the process.
So would it be better if the lawyer does that, or you just be the guide on the side and the person who feels offended does that?
It depends on the circumstances.
Okay.
Oftentimes, there's more of a response when an attorney brings the information to the police department. Sometimes it's nothing. Sometimes there is something to it. But the police department usually will get to the bottom of it. If they don't and it continues, I think it's fair game if they've now charged you with a crime, that if you think it's relevant and you can try to get it in, bring it up. The judge may or may not find it to be relevant, but that's part of what you do as an attorney.
Okay, that's part of all grist for the mill. And let's assume that policemen all want to do well, do right, and be good. But sometimes you might find, I'm sure we've heard, that there could be a bad cop, and they do protect their own, just like politicians, et cetera, et cetera. So I think that it says if you are a person who's feeling like you're being unduly harassed, then it's a good idea for them to call you or contact a lawyer somehow to see if you can help see that through, to see if you can get to the bottom of it in ways that perhaps they can't before it ends up being a real problem.
There is a process, and we're familiar with the process, and we can help a client become familiar with the process or help them through that process.
Good to know. Do you find in the state, even without naming names, this state or Massachusetts when you're practicing, do you find that most prosecutors are very willing to work with you? There is a built-in adversarial relation.
Absolutely.
The system is designed to be adversarial, but most defense attorneys and most prosecutors work with each other on a daily, if not weekly or monthly basis. And you're not going, I never had a prosecutor do something to me where I felt like I have to hold that thought and say, I'll see you again. Usually we know we're going to see each other again, and we're fair up front and honest with each other.
Good to know. Thank you for tuning in to the discussion of legal matters. It will continue. We hope you're better prepared after listening to this segment. Stay tuned.